Inherent jurisdiction, the context of the above topic. The root word is in here meaning to exist as a permanent, inseparable or essential attribute or quality of a thing, to be intrinsic to something. The term jurisdiction has been defined by the Black's Law Dictionary as a court's power to decide a case or issue a decree, a geographic area within which political or judicial authority may be exercised, a political or judicial subdivision within such an area. Both the terms read together would mean a permanent, essential and intrinsic power of a court to decide a case or issue a decree within the specified geographical area and within the specified judicial subdivision. In British civil procedure, the terms traditional and extended inherent jurisdiction are used keeping in view the principle laid down in Grape v. Loam. The court has an inherent jurisdiction to make an order for the purpose of preventing abuse of its procedures. This jurisdiction is a fertile source for procedural development. It was also held that the High Court has jurisdiction to make an order, which may perhaps properly be described as an order for an interim remedy, restraining a person from initiating civil proceedings without the permission of the court, where the proceedings will be vexatious. In another case, it was said that CPR serves to bolster the principle that in the exercise of its inherent jurisdiction, the court has power to restrain litigants from disturbing the orderly conduct of court processes. In the case of Bhamji v. Fosdick, the Court of Appeal referred to the relevant authorities and restated the principle that every court has the power to protect its process from abuse. The court emphasized the element of the overriding objective that speaks of the need to ensure that in dealing with a case justly so far as practicable, the case is allotted an appropriate share of the court's resources whilst taking into account the need to allot resources to other cases. In this case, the court reclassified traditional and extended civil restraint orders, where a court was persuaded that a solicitor had not acted negligently in continuing to act for a company which had been struck off the register. Nonetheless, the court was able to make an award of costs against the solicitor for wasting the time of court staff. The defendants were clearly in a position to know the status of the company. This term of inherent jurisdiction is one of the most frequently used terms, but at the same time, most lawyers would not be able to adequately define it. At the same time, most judges are anxious to pass just and equitable orders, but are not sure of the express provision. An unprepared lawyer who is not aware of the relevant provision insists the court to pass order under its inherent jurisdiction, and the court is not sure whether it can do so. The inherent jurisdiction was originally conferred on the superior courts of the common law in England and was derived not by virtue of any statute or rule of law, but by the very nature of such superior courts, the inherent powers being intrinsic in stem. According to accepted standards of statutory construction, the very term inherent jurisdiction clearly exhibits that it requires no authorizing provision, hence the term inherent. In determining the term inherent jurisdiction, a number of judges and jurists have resorted to the definition from Halsbury's Laws of England. In sum, it may be said that the inherent jurisdiction of the court is a virile and viable doctrine and has been defined as being the reserve fund of powers, a residual source of powers, which the court may draw upon as necessary whenever it is just or equitable to do so, in particular to ensure the observance of due process of law, to prevent vexation or oppression, to do justice between the parties, and to secure a fair trial between them. The doctrine of inherent jurisdiction applies to an unlimited number of situations.